Okay, so the People AG and O'Brien said this, and what you need to know about the exclusionary rule is that the exclusionary rule was originally set down in this case called O'Brien, but it was reformulated in a case called Kenny, and it was reformulated again in a case called JC. So even though I teach this the same way every year some students will say, oh, the rule is the rule in Kenny, okay? Even though we spend loads of time on it. If you get the rule wrong, then your interpretation of any exam question is wrong, okay? So you have to make sure that you get the right rule, and the right rule is O'Brien reformulated in JC, because they reverted back to the O'Brien rule, but they put more, I suppose, protections around it than were previously there. We'll talk about it now in a minute anyway. Okay, People AG and O'Brien, Judge Walsh laid down the following fundamental principle. He said, where evidence is obtained as a result of a deliberate or conscious breach of a constitutional right, it must be excluded save in extraordinary excusing circumstances. Now that actually says a lot, okay, because it says, if evidence is obtained as a result of a deliberate or conscious breach of constitutional rights, it must be excluded except in extraordinary excusing circumstances. And they're the three important things to take from that, okay? So the word deliberate or conscious is what's given rise to the reformulation. So the reformulation in Kenny and then the reformulation again in JC. Because in O'Brien, what the court said was I'm probably going to say the same thing again, but they said that the evidence had to be obtained. No. Where there was a breach of a constitutional right in obtaining the evidence, the person who breached the right, which for the purpose of this course is usually the Gardaí, had to know that they were breaching a constitutional right at the time. So they to deliberately and consciously choose to breach a constitutional right, okay? They said if you could prove that they knew that they were breaching a constitutional right, then the evidence that they obtained on foot of the breach had to be excluded. Except, they said, in these extraordinary excusing circumstances. And extraordinary excusing circumstances that they talked about in O'Brien were to save the life of a victim in peril or to prevent the imminent destruction of vital evidence. Okay? If either of those things arose, then you could breach a constitutional right, but still use the evidence that you obtained. Okay? It's going to make more sense to you in a minute. The examples that you'll see, and the best examples to give, are things like, you have a right to inviolability of the dwelling, okay, under Article 40.5. That means that you have a right to refuse somebody access or entry into your house, okay, because it's your dwelling. And people can't just come in whenever they want. But, obviously, when the police or the guards get a search warrant, and they execute that search warrant by entering your dwelling, contrary to your wishes, that's a breach of your right to inviolability of the dwelling, okay? But Article 40.5 again says, no person, you can't enter onto any person's premises save in accordance with the law. So they're entitled to enter onto your premises with a valid warrant. The issues arise if they enter onto the premises, they seize evidence, and later transpires that the warrant wasn't correct, or that there was a defect on the warrant, or a defect with the issue of the warrant, or on the face of the warrant, okay? So that would be an example of where the inviolability of the dwelling, which is not an absolute right under 40.5, was justifiably restricted by the issue of the warrant, but if the warrant's defective, that's a breach of your constitutional right to the inviolability of the dwelling. So if it's executed and it's defective, then they have no right to be there, because the warrant doesn't give them the right because the warrant is defective, okay? So that's one of the examples of a breach of constitutional rights. So thereafter, every piece of evidence that the guards obtained on foot of the defective search warrant becomes fruit of the poison tree. And that means it can't be admitted in evidence. So once a judge is satisfied that the warrant was defective, it can't be admitted. Now, under O'Brien and the way O'Brien stood, if the guards didn't know that the search warrant was defective, and remember, search warrants are issued by district court judges, but a lot of them are issued by police commissioners. And it's an administrative function. So it's, they write in the time, the date, they say who can execute the warrant, they say for how long the warrant will stand, and then they give it to the guards. They write out the address that the warrant's to be executed at. But for example, in the case of O'Brien, the address was incorrect, very slightly incorrect, but incorrect. So that is a defect on the face of the warrant. But what the court said in O'Brien was, well, it wasn't a deliberate and conscious breach because the guards didn't know that the warrant was defective. Okay? And they said on foot of that any evidence that was recovered on foot of the warrant, the defective warrant, could still be admitted. Okay, so that's how they interpreted deliberate and conscious. Did the guards know that they were breaching constitutional right? Did the guards know that they shouldn't have entered the premises on foot of the defective warrant? And they said unless you could prove that they actually knew, and the guards gave evidence at the time, we didn't know the warrant was defective. The warrant was issued, we were told to execute it, we went in and executed, we didn't know that there was any defect in the warrant. Okay? So you'll see what the